Can a prohibited person have access to your firearms? Let's talk about that. Hey everybody, this is Mike with Personal Protection Academy. Let's talk about prohibited people and access to your firearms. First of all, what is a prohibited person? It's a long, complicated list of people who have committed any felony and certain misdemeanors. A lot of other reasons that make someone a prohibited person. A prohibited person is a minor. A prohibited person is anyone who is addicted to narcotics. A prohibited person is anyone who's ever denounced their citizenship. Or a prohibited person is somebody who's had a less than honorable discharge. A prohibited person is someone who has committed any felony and some misdemeanors. A prohibited person is also someone who is, according to the law, mentally defective. They had a 5150 or they've pleaded insanity in a court case. Someone who the judicial system has deemed mentally unfit. There's a lot of other ones. If you've ever committed a misdemeanor domestic, you're a prohibited person. If you've ever had a misdemeanor assault with a firearm, that's a prohibited person. There are also prohibited classifications that have temporary restraints on possessing firearms. 5-year restraints, 10-year restraints, gun violence restraining orders, and other things like that. This makes someone a prohibited person. That means they cannot own a handgun, touch a handgun, fire a handgun, or have access to a handgun. So the list of what a prohibited person is gets longer and longer. A recent passage of SB 2 has added to that list of prohibited people. But looking at what a prohibited person is, I've just given you the most common ones. But what can they and can't they do? Well, what about my crazy Uncle Ted who committed a felony 30 years ago, and he's been a great guy, found Jesus, and now he wants to go out shooting with me? No. If crazy Uncle Ted has a felony, he's not received a governor's pardon or had his record expunged, he can never touch a firearm. He can't have access to the firearm. You legally, while you're standing in your house, if there's no prohibited people there, you can put your firearm on the kitchen counter. A minor, someone who's had a psychiatric hold, someone who's had a misdemeanor domestic, someone who's ever committed a felony walks into your house, you have to put that away. They can't have access to it. They can't have access to the key that unlocks your safe or the combination that unlocks that safe where your firearm is stored. So you have to be careful to make sure that if you have somebody in your life who is a prohibited person, they can't have access to your firearms, right? That doesn't mean you can't carry concealed around them. You absolutely can. That gun is in your possession. You are controlling that firearm. They can be around you, but they can't touch that firearm. They can't have access to it. You cannot relinquish control of it. So be careful. If you have someone in your life who is a restricted person and they cannot have access to a firearm, just obey the law, make sure they don't have access to it. It's kind of confusing. Look into it, check out the penal codes, and talk to an attorney if you have any questions. What about you? Leave your comments below and tell me what you think. Is California law too restrictive? Should some of these people have access? Are you okay with it? Okay, until then, we'll see you next time on the range. Bye-bye.